So I'm immediately introducing the first speaker of today, Dr. Niovi Vavoula. Niovi is Associate Professor of Migration and Security, and it's a leading scholar in the field of artificial intelligence and databases for migration and asylum in Europe. Niovi works at Queen Mary University of London, and she is affiliated to several networks, including the Odysseus Academic Network for Legal Studies and the European Criminal Law Academic Network. She has published extensively in the field, and also very recently an important book on these topics. So I will immediately leave Niovi the floor for her presentation, and thank you for the patience. Okay, it's better you come here. Yeah, so your slide.
Hello, everyone. Good morning to all of you, both in presence and online. As I see you, I think that this is a great mixture of students and participants in this summer school, because it's going to make the points that I would like to make today very prominent and very visible, because I see a great variation of people in terms of gender, in terms of age, in terms of color, ethnic origin, race, all these issues that are going to be discussed in the next hour. So as we're setting up the presentation, I want to ask you all, I assume that some of you are students here, so you have a student visa probably, or in order to travel as a tourist, you may have been in need of getting a visa to visit the United States or Australia, Canada, or a European country. And I was wondering whether you would like to raise your hand, or like to those of you who would prefer your application to be determined by a machine, and afterwards to those of you who would prefer any application to be determined by a human officer. So who would prefer actually the machine to make a decision, whether you get a visa, a travel authorization, a residence permit? Who would prefer that? Also online, can you raise your hand, use the raise your hand function to anyone who would actually prefer a machine making such decisions? One? No, don't be afraid. Actually, in order to make it easier for you, there has been research actually saying that a lot of foreigners would actually prefer a machine to make a decision on the merits of their application. What about online? Anyone? Some hands? I see some hands as well, but I would say that it's quite clear that this is a minority. And to the rest of you, I would suppose that you would actually prefer a human officer to actually decide your application. Can I ask whoever wants to raise your hand why you would prefer actually a human to make a decision on your application? Or whether to enter, the borders, why you would prefer a human? Yes, please.
Thank you. For me, I prefer human officer to take a decision on my applications, because in the case of any mistakes, the decision they are filled by me. But when it is not a human officer, I will have limitations over that.
Like what limitations do you foresee?
Yeah, it will not be easy, because when, like artificial intelligence made a decision, it is not a human, and there is no clear accountability. So the decision is very automatic.
It's very automatic. Okay, I see. Anyone else? On the other hand, why would you prefer the machine to make a decision on your application?
Thank you so much. Actually, I would prefer a human officer, because as far as artificial intelligence can make error, and sometimes when it makes error, I cannot challenge.
You cannot challenge.
So that is a problem. It can violate my right to appeal. I may try to present myself and defend. There is no way to challenge this issue.
Both your answers point to a very important issue which has to do with remedies. How do you understand the output of the machine, like the decision, and how then that output can be challenged before a court or before administration? This is a very interesting problem, and I think at the heart of this problem is the potential risk of discriminatory treatment by the algorithm, by the AI system. So this is what we're going to discuss today. So thank you very much. And I really like the fact that we had a minority of trusting the machine, because as I will try to show in the presentation, there are very valid reasons to be in fear of what the machine is going to give us a guidance. And at the heart of these concerns is the risk of a discriminatory treatment. And by discriminatory treatment, as I will show, we mean both direct and indirect discrimination. So we're going to discuss that aspect quite prominently. So in order to understand how we're going to structure this lecture, hopefully I can someone help me? How I have to do it through here. All right. Should work? No, it's fine. Perfect. Okay, so what we're going to be doing today, and I do have quite a lot of slides, so maybe some stuff are going to be discussed a little bit less, is that first of all, I would like to situate why AI has been on the rise, particularly in the field of migration, asylum, and border management, and why the risk of discrimination in this particular field may be more prominent than in other fields. And what is the characteristic of immigration law, which makes the application of AI technology more prone to discriminatory treatment of foreigners. Afterwards, I would like to discuss with you what type of biases we can see in artificial intelligence in migration. And we're going to see that there are different types of biases that can be found at different stages of decision making. And I'm going to explain that as easily as possible. I promise I'm not going to be too technical. And then I'm going to link the biases with issues of legal nature with regard to the law of non-discrimination. And again, situate why discriminatory treatment is very, very possible in this field. Afterwards, we're going to have two short case studies. I'm really sorry, but unfortunately, these developments are primarily being deployed in the so-called global north countries, also Australia as well, which means that by default, the case studies cannot really take into account global south literature because these are deployed in the global north, so the legal framework comes from those countries. So we have one case study from the European Union, another one from the UK, both of which we're going to see where the discrimination can lie. So without further ado, I would like to, probably maybe it has been mentioned, but just, as a recap, we need to remember that the field of immigration law is a field where there is a lot of discretion by the states and a lot of discretion in decision making, which means that this comes from very early literature, very early case law, already by the Supreme Court of the United States in 1892, which basically said that it is an accepted maxim of international law that essentially states can decide who to admit in their territory and who they cannot. So by default, and I think this is something to remember, is immigration law is a field which accepts differentiated treatment between citizens and non-citizens. And that differentiated treatment could means that there is potential of discrimination that is already embedded in the legislation, either directly or indirectly. So keep that in mind because it's a very important bedrock of immigration law. So we're going to see how essentially the acceptability and acceptance of differentiated treatment between citizens and non-citizens, if translated and coded in artificial intelligence, it can have even wider effects. So if we go also and see, for instance, in the UN Human Rights Committee General Comment number 15 on the position of aliens under the Covenant, we see that it says that the Covenant does not recognize the right of aliens to enter or reside in the territory of a state party. It is in principle a matter for the state to decide who it will admit to the territory. And then, so you can see that this is embedded, this is very much accepted. We can discuss whether this is correct or not, but this is the basis on which we are working, with which we're working. That's something to keep in mind. So why migration has been such, and you may have already realized in the previous days that the migration field has become a prime laboratory for testing artificial intelligence tools. You may have heard about the triaging system in the UK. Daria has done amazing work. I know she presented on Monday. She probably has mentioned the mapping of all the different AI tools at European level, but also in Canada, in the United States, in Australia, we see a lot of rise. Why in migration field? One is because there is, with mobility being on the rise, there is a high volume of decisions that need to be made at different points. We mean decisions on visas, on travel authorizations, on asylum applications, on whether someone should be detained, decisions that have to be made at different places, extraterritorially, when someone is still in their country of origin, they apply for visa, at the borders, when someone submits their documents in order to enter on national territory or inside the territory. So there is a lot of decision making to be made. And that decision making, as we said, is highly discretionary. And therefore, there has been a lot of discussion as to whether artificial intelligence can actually streamline and make things a little bit more, not only efficient, and but also more straightforward, with more certainty and less discretion, in the sense that if such highly discretionary decision-making can take place, maybe we will have certain rules, and it's an AI machine and system that makes a decision, that actually we don't going to have that many discretions and many differentiated and variations in the decision-making. That pretty much similar cases will be treated in the same manner, which may not be the case. So maybe AI would ensure more uniformity in decision-making. And because there is a lot of decision-making to be made, that this AI can actually help in combating backlogs of different applications. At the same time, we need to remember that migrants and refugees may have fewer protections than citizens, not only because, as I said, this is by default a field of discretion, where states enjoy quite a lot of discretion, but because we know that structurally this is a field where there is a lot of racism, a lot of xenophobia, so there are a lot of different things there are a lot of considerations that play out in decision making. Also, because individuals who may be outside the territory or at the borders enjoy fewer protections. They may be deported, they may be sent back, they have less leverage, they may have no legal assistance, they may not understand the language, they may not have effective remedies. So by default are in a weaker position than citizens. So all these factors make the application of AI very, very promising, that is going to actually do good rather than do bad. Is this the case? I'm not entirely sure. Actually, I think quite the opposite. So something else, I'm going to have the slides available, so you don't need to take photos. If you want to take photos, that's absolutely fine, but you will have the slides as well. And for questions, it would be better if we combine all the questions at the end. Maybe I will reply to some as we go through. Something that, so a key thing to keep in mind is that artificial intelligence, and maybe you have already realized that in the previous days, it poses a series of different human rights challenges to many different human rights. But at the heart of these challenges is the principle and right to non-discrimination, which is what we're going to be looking at today. So discrimination essentially refers to an unfair, unjust treatment of people based on certain characteristics. The problem with discrimination is that in many cases, it's very difficult to measure it directly. It can also be very subjective as a concept, but at the same time, it is very much related to a very important human rights, which is the right to human dignity, because discriminatory treatment can have a real effect on life chances, as well as well-being and mental health. At the same time, discrimination is very much linked with the concept of bias, which we're going to spend quite some time explaining. Bias means the inclination for prejudice for or against something, and it exists when a decision maker's actions are changed by taking into account either a irrelevant consideration that they shouldn't take, or failing to take into consideration something that they should have. So, for instance, bias would be when someone takes into account the color of a person or their religion in order to exclude them or make a decision affecting them, when the color or the gender or the ethnic origin should not play such a role. Non-discrimination is very much linked with other human rights that are affected with the use of AI. Privacy data protection, because to create the algorithms, to create an AI system, you need a lot of data. And effective remedies, which has already been mentioned. Everyone is scared of how AI will actually be very opaque, will not allow people to understand how a decision has been made, and that will affect prospects of getting it reversed before administration or courts. So, yes, I understand that effective remedy is a very important procedural right, but before that comes a substantive right, which is the right to non-discrimination. And as we will see in the case law of the Court of Justice of the EU, in order to tackle discrimination issues, you need to understand the algorithm, and then you can challenge it before the court. So it is also a prerequisite to understand potential discrimination issues in order to have it as a ground for challenging a decision. So how can AI discriminate? And at the heart of this is the concept of bias. So we're going to be looking into the application, the life cycle of an AI-based decision-making process at 3 different stages. One is at the level of designing the AI system and training the data before deployment or as they are deployed. The second is at the stage when there is decision-making on who to apply the AI system. And the third has to do with what is called cognitive bias in assisted decision-making. And you're going to say, isn't it? I'm not understanding a thing. So let's say that the AI system, in the vast majority of times, does not make a decision on its own. Okay. There is what is called, probably you've heard the term, the human in the loop. There is an officer who takes the recommendation of the AI system, and on the basis of that, they need to make a decision as a human assisted decision, but made by the officer. Is there bias there? How does the AI system affect the decision-making by the officer? So we're going to look into all these 3 stages and see where there can be bias, because we see that in the design and training of bias, we can have different issues that raise discrimination concerns. We may have unrepresentative data, we may have bias inherent in the data sets. The data may be infected by discriminatory decision-making in the past. There may be used proxies in the design of the algorithms, or they may be biased in the mode of the training itself. Also, at the decision-making stage by the author, you may have heard of information bias, or maybe there is selective adherence, and I'm going to explain all these concepts, so don't worry, because they may be a little bit difficult to understand, but I'm going to make them quite clear. So already there you can see that a lot of things can go wrong in the application of AI systems at many different stages. And therefore, we may call into question the compatibility of AI systems in this field with the principle on the right of non-discrimination. So what can go wrong in the design and training of the data? So as you know, in order to design an AI system, you need a lot of data that are in principle anonymized. That statistical data are then coded. You could draw correlations and patterns from the data, and these patterns and correlations are then translated into actionable algorithms that give that flag potential specific individuals for further assessment, or they they sift through the data and they say this particularly risky, this is maybe a little bit less risky. So this can I hear something at the back. Could someone please close your microphone, because I hear feedback. Thank you very much. So the quality of the training data can affect very much the output. If you don't put good data in the systems, the algorithms that you're going to create are going to be problematic. You're going to end up with really bad recommendations. This is very much understandable. So machine learning techniques can recognize patterns within the data and take decisions based on such pattern recognition. So if data input is tainted, the patterns generated will replicate that taint. And that's very, very clear. And there is an assumption and considering that the aim of AI is not necessarily to change decision-making, so not to alter the content of the decision-making. So it's not there to allow more people to enter, to give more visas, to give more, to recognize more asylum applications. It's there to assist human decision-making, which means that it's bound to replicate patterns of past decision-making. That's what it aims to do. It doesn't want to allow more people in. It wants to assist humans so that certain considerations that have already taken place are now going to be done automatically by the machine, so that the officer will not have to do these considerations themselves. So there is therefore an assumption that the decision-making by the AI system is not going to be revolutionary and very much different from past decision-making. It will resemble the past decision-making. And there's the first danger, which is to reproduce existing biases. So in the training and designing of the AI system, when the algorithm is learning the correlations, those correlations can be discriminatory. And why this? Because the data that are being used to create the algorithm can be non-representative. Where, for instance, I'm going to explain it a little bit more. So the data may be non-representative or incomplete. You may not have full data, and then you have algorithms on the basis of specific data, which will going to give you specific results, not taking into account the full picture. You may have bias, which is inherent in the data set. You may have data which are infected by past discriminatory treatment and discriminatory decisions. You may not use protected characteristics such as race, ethnic origin, religion in the design of the algorithm, but you may use proxies of for protected characteristics. And I'm going to explain that in more detail later. Or there may be bias in how the training is being done, considering that the training is being done by humans, who may also have their own subconscious or conscious bias. So let's unpack a little bit that in more detail. So when we say unrepresentative data, it means that you may have sampling bias, and you may see that we have a lot of different categories of bias, one of which is sampling. So you have poor data, you have non-representative data because you don't have enough. So it is something that by default can happen because you don't collect data on everyone who has been refused a visa or on everyone who has been refused entry at the border. You may have from specific groups of individuals or in respect of specific periods of time, not taking into account other periods of time. There is also potential that the identity of inputters of data, so the engineers, is unrepresentative. So the engineers themselves that are doing the collection and design of the systems are themselves non-representative of the full spectrum. You may have the white, young male engineer, which means that by default, you don't have full representation in the design of different categories. You don't have someone who is older, more experienced, perhaps, women. You may not have Black engineers or brown engineers, so you don't have full representation also there. So that's one, not good quality data in the design. Then the data that can be used could have inherent bias in the data set. So for instance, and I will make some examples which are outside migration context in order to illustrate the point. So we know that in Google News articles, the algorithm that can sift through different articles exhibits male and female gender stereotypes, whereby females are associated with specific professions such as nurse and nanny, whereas males are associated with professions of doctor and bankers. So this is an inherent bias in the data set, which afterwards denotes an inherent bias in the data set, which means that by default, the output will also be biased. Something that is very common in migration is that the data that are being used for the training are infected by past human discriminatory decisions. So for instance, if women in loan applications, if historically women's loan applications were rejected more frequently than men's, the AI based on such training data is likely to reproduce the same pattern. To give you an example from migration, let's say that people from South Sudan, to make this example, are discriminatorily denied a visa application. And therefore, if you get the refusals of these applications of Sudanese nationals, and then you code them, and there is an algorithm that is going to reproduce the past decision-making, which is discriminatory, South Sudanese are going to be prevented from getting a visa because the algorithm is going to replicate the past decision-making, which was discriminatory. So you can see already how this can play out in a lot of contexts and in migration and can be very, very challenging. This particular issue is much more prominent in fields such as immigration or policing, where discrimination is significant. So you may already know that in stop and search checks on national territory, police officers are more prone to stop brown or Black young men as opposed to a white male to do a search. The same also happens with immigration checks on national territory. So therefore, these inherent discrimination, if coded, can create a lot of bias in the algorithm. The fourth dimension where we can see that there may be discrimination issues is when the law is seemingly neutral in what characteristics are going to be used to create the algorithm. So no race, no religion, no ethnic origin, so no protected characteristics are to be used in creating an algorithm. So for instance, they wouldn't say Muslims or from who are, Black Muslims are being prevented by default to, are not going to get, for instance, a travel authorization easily. So they are by default flagged as risky, but there may be no protected characteristics, proxies, which will be doing pretty much the same thing. So if proxies of protected characteristics would be an example like that. So let's say that instead of race, which is a protected characteristic, a system would flag someone for further examination of their visa application on the basis of nationality. So the nationality may be used as a proxy for a protected characteristic, which is the race. Or the postcode, when you apply for a visa or a residence permit, you provide your postcode, your address. So the postcode, which is not a protected characteristic, may be used as a proxy for a protected characteristic, which is race or ethnic origin, because the postcode denotes where someone lives. And depending on where someone lives, this may be inferred what is their ethnic origin, what is their race. So you can see that seemingly neutral characteristics can be used to design the algorithm, and therefore not the protected characteristic will be the problem, but actually the fact that they are used instead of a protected characteristic as a proxy. So again, even if the training data do not contain protected characteristics, they may contain proxies, and there is a strong correlation between the proxy data and the protected characteristic. So the last dimension is when there is bias in the mode of training. And by that, I will give a very specific example, and I think you will understand. Let's say that there is a discriminatory algorithm that flags as risky all male adults with primary education from Egypt. Okay, we can see that potentially this is there are some aspects in this algorithm that may denote indirect discrimination against male adult Egyptians with primary education. Okay. They apply for a visa, a lot of whom are rejected because the system flags them as risky. Then the human relies on what the machine said, and they deny the visa. That new rejections of visa applications are going to create new statistical data. And those new statistical data are going to feed again the algorithm, so that when new Egyptian male adults with primary education apply, they will get again flagged as risky. And again, this is a vicious circle. You understand the problem? So essentially, what happens with a discriminatory algorithm may define a decision-making. That decision-making creates new statistics, and those feed again the algorithm. So you have a vicious circle when there is a reinforcement learning, as I said. The system is reinforced by when they get the answer right, and this perpetuates the cycle of discrimination. So you can see that already in the design and the training, a lot of things can go wrong. So, so let's see how things can go wrong, particularly in the field of migration, with some examples. I have already mentioned some, but these are not the only ones. So in the training of AI systems in the field of migration, a lot of things can go wrong because we have many different applications, which I'm pretty sure you already know, and you can think of examples apart from applications for visas or asylum, etc. Because if the training of the data is discriminatory, things can go wrong, not only if someone applies, but also if someone gets recognized by a facial recognition system. So you may have heard already, and if not, I'm telling you now, that facial recognition technology, for instance, cannot be fully reliable when it comes to brown and black women in particular, which means that already the design and training of the data, not enough facial images of those people have been used in order to train the algorithms, which means that facial recognition technology does not work well in those cases. Another example where we have non-representative data, for instance, has to do with natural language processing techniques. So in order for voice recognition or language recognition, dialect recognition, you need to have trained the data with many, many different voices and many different dialects. A lot of you come from different countries, so you know a lot more on how many dialects are being spoken in your country. But it's very well known that AI is not trained enough in order to recognize all the different dialects. So you can see that a lot of things can go wrong there as well, because if the dialect, if someone says that they are from a particular area where they speak a particular dialect and the dialect recognition system does not do the correlation, does not function well, the individual will have a credibility problem because they may say, you're lying. The system doesn't recognize that dialect, you are not in face of persecution in that particular area, you are lying, you are not a credible asylum seeker, for instance. So a lot of things can go wrong in many different stages. So the second, which is a more general concern, but it has to do with what I mentioned earlier about how AI, how migration is laboratory for AI, has to do with the discriminatory application, which means that this is particularly relevant here, that states decide to which groups of individuals to apply a specific AI system. And I'm going to mention here the example of the Netherlands, when, for instance, we know that in the Netherlands, a seemingly system which was outside migration context, which has to do with the benefit fraud detection algorithm Siri, was considered as discriminatory because it was only used predominantly in low-income neighborhoods. So this may not apply fully in the field of migration because, as we see, and we will see, pretty much all foreigners, when they come to different countries, will face different types of algorithms, but there may be algorithms that are particularly applied to discriminate against specific groups of individuals. Here, in the Dutch algorithms, the discrimination was against the low-income neighborhoods. The UN Special Rapporteur on Explicit Poverty and Human Rights in 2019 precisely said that whole neighborhoods were deemed suspect and made subject to special scrutiny, which is the digital equivalent of fraud inspectors knocking on every door in a certain area and looking at every person's record in an attempt to identify cases of fraud, while not such scrutiny is applied to those living in better off areas. The third one, which is very, very important because it is considered as the flagship of using AI in migration, has to do with the human in the loop. So you may have heard the argument that what's the harm in using AI systems when ultimately the decision is made by a human, the human in the loop. There is always there someone who is ultimately responsible for the final output. So this is a very, very prominent argument that AI is not as harmful because at the end of the day, there's always the human who's going to make the decision. The problem is that there is a lot of research saying that actually the machine plays quite an important role in assisted decision-making. And this plays out in many different ways. there is some literature which talks about what is called automation bias. Have you heard the term? Does anyone heard the term? Who can say, like, very briefly what it means? Anyone? Or you can guess what automation bias may mean? Automation bias would be in the case where you see the output of the machine, the recommendation of the machine, and blindly not questioning that recommendation and relying directly on that without further look. Automation bias is basically on the is based on the perception that technology is neutral, logical, and consistent. And however, at the same time, it supposedly technology heightens legitimacy, but weakens human accountability, as was mentioned earlier. So automation bias is one line of thinking that actually it's, at the end of the day, the human in the loop is non-important because they're pretty much going to do whatever the machine tells them. Newest literature actually doesn't say that there is full automation bias, but actually says something a little bit different. The argument is that the human in the loop is more prone to question the output, the recommendation by the machine, when that recommendation does not sit well with their own stereotypes and biases. And in turn, the human in the loop is more prone to follow the recommendation when it correlates and coincides with their own stereotypes and biases. So let's say that in Greece, for instance, where I come from, for years, there has been quite a lot of bias and discriminatory treatment against, and quite a lot of prejudice against Albanians. Okay, so you have there a border guard who is designing application on a residence permit assisted with AI on an Albanian national. If the Greek border guard shares the bias and prejudice against Albanians, and the recommendation by the AI system is that this Albanian applicant is risky, they may be more prone to follow the recommendation and deny the residence permit. But if, for instance, there is a recommendation that an Australian who applies for a residence permit may be risky, and the border guard, the immigration officer, does not share that perception that Australians who are white, male, may be risky, they may be more prone to actually look further into the specifics of the application in order to see whether the AI system has been wrong or not. So you can see that the human in the loop and the rigorousness of the manual examination of an application can depend quite a lot on the recommendation by the machine. The third one, the third line of thinking in that regard has to do with what is called anchoring bias. And anchoring bias basically means that decision makers tend to rely too heavily on the first piece of information they receive on a topic, regardless of the accuracy of the information. This is quite interesting concept, which means that if the machine tells them no, and this is, the primary piece of information that they have, they may not bother looking into the specifics of an application. So again, different lines of thinking, all of which boil down to the fact that the human in the loop, unless they are fully well trained and they have a very good understanding of fundamental rights, and they can be ensured that they are free from biases, conscious or unconscious, which is very, very difficult because we are all humans. The human in the loop may rely quite a lot on the AI system, and that may affect the final decision making, which means that essentially the human in the loop may not be a sufficient safeguard. So that, and I'm not going to read everything, this comes from the UN Special Rapporteur on Contemporary Forms of Racism, who in 2020, she recommended a moratorium on the use of AI systems, which was quite wishful thinking because this is not going anywhere, and actually said, and I'm going to quote only the relevant parts which are highlighted in the text, that we need to acknowledge that the heart of the issue is a political, social, and economic one, and not solely a technological or mathematical problem. And this bodes very well with something that Mirko and I were discussing earlier, that actually the use of AI in immigration is not a technical issue, and it's not a technical solution. It's something that is presented as a technical solution, but actually has a lot of legal implications, and ultimately it's a political choice. The UN rapporteur goes further to say that these pathogenies will not be cured by more perfect modeling of equality and non-discrimination. So essentially, it's not a technical problem to be solved. And thinking and action that seek to combat racial discrimination in the design and use of emerging digital technologies should not be the exclusive or near exclusive terrain of technology experts, and affected racial and ethnic minority communities must play decision-making roles in the relevant processes. So essentially bringing into the discussion the subjects, the individuals who are affected, not only the decision maker or the industry that wants to sell their products. I'm mindful that I'm already at almost 45 minutes, so I will try to get a little bit faster because I would like to 11:50, which gives me including the Q&A, that's 11:50. Okay, I still have quite a lot to say, but as you have already realized from the quite dystopian picture that I have painted, there are a lot of problems, a lot of things that can go wrong. So how do these translate now into challenges for the right to non-discrimination? So the right to non-discrimination is embedded in the majority, basically in all the international human rights law instruments. And the objective has been to guarantee that human rights are exercised without discrimination of any kind based on race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status such as disability, age, marital, family status, blah, blah. There's quite a lot. The first part that I mentioned, up to the point of where it's mentioned status, these are all the protected characteristics that I mentioned earlier, which means that these should not be used in the division of algorithms per se. Okay. This and the prohibition of racial discrimination is something that it's non-derogable even in states of emergency. So the stakes are really, really high. This comes from the Human Rights Committee in General Comment number 29 of 2001. So the standards are pretty high. I'm not going to discuss the relevant provisions. You can read, the slides are going to be at your disposal. Suffices to mention that the UN Declaration of Human Rights refers to non-discrimination, Article 7. International Covenant on Civil and Political Rights also does in Article 26. International Covenant on Economic, Social and Cultural Rights is the same, but also at regional level, we have Article 14 of the European Convention on Human Rights, Article 21 of the EU Charter of Fundamental Rights, and something to keep in mind, at least at EU level, we know that the right to non-discrimination encompasses both direct and indirect discrimination. And direct, it may be a little bit more difficult to find, because it's more easy to spot, and therefore legislation that directly discriminates will be struck down. But indirect discrimination is quite difficult to find, and the devil lies in the details. So the fact that it's also protected is quite important. So what's the difference between the two? Direct discrimination means that treating a person less favorably than others in a comparable situation on discriminatory grounds because of a protected characteristic, as I mentioned earlier. But indirect discrimination refers to situations where an apparently neutral provision, criterion, or practice has a disparate impact, which can be unintentional or not, on a group, putting them at a disadvantage because of a protected characteristic. So cases where proxies of protected characteristics are used are considered cases of indirect discrimination. We're going to be looking at that a little bit more very soon. The leading case at European level is the case of Biao against Denmark, where the case involved the indirect discrimination against non-Denmark born citizens and the right to family reunification, where basically it was said that an indirectly discriminatory measure has no objective and reasonable justification. That is, if it does not pursue a legitimate aim, or if there is no a reasonable relationship of proportionality between the means employed and the aim sought to be achieved. So there needs to be, the principle of proportionality is really central in the discussion in order to see whether something which is neutral may actually have an indirectly discriminatory effect. So how does this translate in the field of migration? So as you can probably guess, the most relevant grounds of discrimination in the field of migration would be race, ethnic origin, nationality, and religion. And particular migrants, asylum seekers, different categories of foreigners are particularly vulnerable to discrimination. And we see, if someone would look into the existing case law, you will see that there is, as I said at the beginning, quite a lot of discretion as to how differently foreigners and citizens can be treated. So there is a lot of leeway given to states as to how to devise their immigration laws. But at the same time, we lack specific case law on technology and non-discrimination. So we are still at this stage where things are being deployed. Some things are still at embryonic stage, are being experimental. So we don't really have an adaptation of the law and the case law to the use of AI in relation to and the discrimination concerns, which is very problematic because we know that discrimination law and migration are not, discrimination arguments are not very strong sometimes in the field of migration. So adding the complexity of AI on top, we don't know how it will play out. But we do know, however, that, as I mentioned earlier, there are already challenges where these characteristics of ethnic origin or ethnicity and race are already playing out in the use of AI, with the example of facial recognition being very prominent. So we already know that when facial recognition, so when someone goes at the border and you have the machine doing a facial recognition and does it against your passport, for instance, it is not well trained so that a foreigner who is black or a woman or brown would go through as easily as a white male, for instance. So already there, we know that there are problems, but without case law. What are the barriers for using non-discrimination arguments? Why is it so difficult? Apart from the discretion that I mentioned, we do have a problem, which was mentioned earlier by your colleagues here. We have difficulty in measuring that there is discrimination. How do we know that another person with similar characteristics was not treated like that, or that all people from a specific group were all discriminated? It's very difficult to find the proof in order to argue for particularly indirect discrimination. So it has been argued that what can be done is to shift the burden of proof so that now the onus of proof is to the claimant, But actually, it shouldn't be the case because in discrimination cases, it's very difficult to find such evidence, especially where the claimants are poorly praised to prove unlawful discrimination. It's covered, it's unrecognized prejudice. The evidence, which is the algorithms, could be at the hands of the state. How do you know that the algorithm used is discriminatory? So how do you find this information? This is a very important barrier. And ultimately, it all depends on the existence and the availability of data which lie with the state that's using the algorithm. So how do you know that when your visa application is being denied and you receive a very generic justification that you pose a security risk or an immigration risk, how do you know that actually it was the recommendation of an algorithm which has been discriminatory when you don't receive much information about the actual content and the decision making, how the decision has actually been reached? So going now into the case studies, I'm going to briefly discuss some case law, not from the perspective strictly of migration, even though some of these cases have a migration angle, where we see that actually the Court of Justice of the EU at European level tries to put some principles and some safeguards as to how automated decision-making can take place. And there are 3 cases in that regard. I'm not going to say the specifics because they are not relevant to you. I'm going to simply talk about the findings. These cases are very important because these are the first examples of case law that we see that actually AI is not to be fully trusted, that there is a quite emphasis, but still there are quite a lot of gaps, and I'm going to say those as well. So the first one has to do with the processing of PNR data. You ask me what is that? When you fly, your ticket, your booking generates PNR data. It generates a record of all the information that you supplied when you booked, from your date of birth and your full details to your full itinerary, to your contact details, to your credit card details. All this is called PNR data. And for law enforcement purposes, to determine whether you pose a risk for terrorism, for attack, or other serious crimes, there is processing of data. For instance, if you fly to the US, Department of Homeland Security will go and sift through, prior of your flying, all your PNR data to see whether you may pose a risk. The same happens also with Europe. So in order to sift through your PNR data, the algorithms are being used, AI technology. So what can and cannot be done is the following. The Court of Justice, in the context of the processing of PNR data in the EU, it said that you need to have algorithms which are reliable and specific. It must be non-discriminatory, and they must be limited to what is strictly necessary. Every hit, so everyone who is flagged as a potential risk, needs to be individually examined by the human. And all the criteria, all the algorithms need to be subject to review on a constant basis. So far, so good. Not fully elaborate, but I guess this correlates very well with what we mentioned earlier. In another case, which had to do with analysis of telecommunications metadata, so data on when you called your friends, your family, of all different people, what was mentioned, what was added is that the models and the criteria, so the algorithms essentially, cannot be based on sensitive data in isolation. So you cannot have an algorithm only based on someone's information about race or about or gender. So you cannot do that in isolation, but you can do it in combination with other data. So it didn't say anything about that. More recently, we had another case about PNR data. And there we had a little bit more of elaboration. I know that Mirko is going to also discuss the case, so I'm not going to say too much. But what was quite interesting was that in this case, it was said that you cannot use machine learning techniques that are basically changing on their own. So which are capable of modifying the assessment criteria without a human intervention. So you cannot do that. This is prohibited because it's too opaque to follow, and to allow for effective judicial remedies. So there is some kind of more saying. So we know that certain machine learning techniques are being prohibited. The court here also mentioned that both direct and indirect discrimination are being included. And it also said that we need clear and precise rules to provide guidance for individual review. So the human in the loop should have clear guidance as to how to treat the result of the machine, which is a new thing, which can be quite good. And at the same time, also it says that the human decision-making should take precedence over the results of what the machine says. So these are quite good recommendations, which take into account a lot of the things that we said earlier. So I know that I want to really give you the opportunity to ask questions. So I'm going to briefly talk about the 2 case studies for another maybe 5-10 minutes, no more than that. 5 minutes. I am just going to give you 2 examples very briefly. The first one comes from the EU. I have quite a lot of slides, so I'm not going to, you can find more information there, or I can send publications to be made available if you want to learn more about potential discriminatory AI tools in the EU. So what I was describing earlier about assisted decision-making by algorithms, this is going to take place in respect of visas, residence permits, and travel authorizations. Travel authorizations are the lighter visa. So if you come from a country that you do not need a visa to come to the EU, I've got news for you, you would need a travel authorization soon. So if you've been to the US, maybe some of you have done the ESTA process. So it's similar to that. So it's a process of pre-vetting travelers so that specific resources are reallocated to people who are really in need of further assessment. So we're talking about AI systems here, potentially AI systems, because it's not clear the extent to which these are pure, simple algorithms or real AI. These algorithms are being used to essentially profile visa applicants, residence permit applicants, and travel authorization applicants. So you apply for a visa and you provide your data, and all your data are then compared to algorithms to determine how risky you are. And then if there is a risk, this is flagged, and then the visa officer will see that the system has flagged you as potential risk, and they make a decision based on that recommendation. Remember how I said at the beginning that sometimes we may have bias in the underrepresentation of information. So in the case of ETIAS and VIS, we may have this problem because the statistical data that are going to be used to create the algorithms will come from member states of the EU, many of which do not have this kind of data. So by default, the data for training will be underrepresenting the member states. They will come from specific ones, not for everything. And also there is potential misuse by the member states. For instance, to determine whether someone poses a risk to public health, they may use data on COVID. Is it relevant to use data on COVID, which is a pandemic, in order to determine who is a risk for public health? I don't think so. So there may be problems there. I had more to say, but I don't have the time, so I'm happy to reply to any comments. And there is also another problem which has to do with the use of proxies that I said, again, in the design of the algorithms. So if we see the legislation, we know that the algorithms are going to be based on specific information. Would be a combination of the age range, sex, nationality, country and city of residence, the level of education, the occupation of someone. Can you think of whether these categories of information can be proxies to protected characteristics? Do you see any of these pieces of information that may be proxy for something that is protected? Can you think of an example? Also online, you can raise your hand. Is there any of these categories of data a proxy for something else. Yes, which one? Exactly, nationality can be a proxy to ethnic origin or race. Anything else?
City of residence as well.
The city or country of residence can be a proxy of race and ethnic origin. So you can see that there can be problems with what I said earlier about not the use of actual protected characteristics, but the use of proxies, which may lead to indirect discrimination. There are some safeguards. I mentioned here, I discussed the issue of the proxies quite a lot, but I don't have the time, so I'm happy to discuss that later. And I'm going to finish with just one sentence about what has happened in the UK to illustrate how dangerous these tools are. So in the UK, and without a piece of legislation so that we really know what is happening, in 2019, there was a legal challenge by a non-profit organization, Foxglove, against an algorithm that was used in the UK for triaging visa applications. So you may ask, what is triaging? Triaging means that you apply for a visa, and then there is an algorithm that is going to classify your application between three categories, whether it's fast lane, which means less risky, which is a green category. The second one, a slow lane, which means that it requires quite a rigorous examination. And the full digital pat down, the red category, which means that this person is really needing very rigorous examination of a very potentially risky person. The government did not want to provide any information about these algorithms, so we didn't really know how discriminatory they were, because they claimed that there was an immigration exemption in the Freedom of Information Act. So we don't really know what was going on there. But we do know that there was an inspection, which was basically said that it would be good, to have a little bit more of information. We know the processes, how they are being used, is only to allocate applications. So trying to justify the system. You know what happened in 2020? So when Foxglove took the case before the UK courts, the UK Home Office simply withdrew the algorithm because they were too afraid of what was going to happen before the court. Because before the court, they would have to disclose to the judge the algorithm, and they were in fear that it will expose the discriminatory treatment of certain visa applicants. So this is a very good example of how discriminatory it can be, to the extent that the government can withdraw an algorithm without even going into the courts because they were too afraid. Now we know that they don't use it, but they are trying to redesign. So I'm going to stop here. I know I went through the case studies quite quickly, but I hope that the slides will provide you some more information. We can discuss it more in the details in the discussion. To conclude, I want to simply say migrants and asylum seekers are in particular a weak position, which means that by default, they can be more prone into the use of these systems. There is potential. One could say, we had this discussion yesterday, that using AI system may be easier to expose systemic and structural discrimination. It may be easier to the extent that there is organized action which puts a lot of burden into NGOs, a lot to communities to organize together in order to strike down potentially discriminatory algorithms. Overall, there is definitely need for a lot of transparency, a lot of accountability, which is very difficult, especially because migration is very much linked to security. So there may be barriers in getting access to algorithms under a security exception as well. But going back to what the UN rapporteur about the moratorium said, it sounds like a very good idea because things are not looking particularly good. However, in reality, we see that there is proliferation of more and more systems, and the only hope would be that these are going to now be litigated before different national regional courts. So thank you so much. I look forward to your comments, especially for these issues that I brushed through, and any comments or queries are very much welcome. So feel free, there's no stupid question. Yeah, so this is a difficult topic. I understand that.
Thank you, Niovi. So it's yeah. No. Yes, it's closed. Yeah, maybe computer. Okay, just a word to say thank you for your generous presentation. Also charting the gaps in this new field of studies, let's say relatively new. We have 20 minutes for a Q&A. So I kindly invite, okay, I do already see some hands raised online, and I will take them while waiting for you in the room to prepare your questions. So I don't know if the order is the right one, but I see Agnese Palazzi. Okay, so Agnese, you have the floor. Thank you. And please try to be to put your question quite rapidly so we have time for everybody. Thank you.
It will be a very quick question, actually. Thank you very much for your...
We cannot hear you, Agnese. I don't know if it's...
Can you hear me? Can you hear me now?
I can hear you.
Yeah, okay.
Okay, can you hear me, right?
Sure.
Okay, thank you. Well, thank you very much for your presentation. It was really interesting. I have just a really quick question concerning methodology. Actually, Professor Oskul, in the previous days, she told us that as a tool of methodology, since it is not so transparent how the AI systems or AI tools are implemented in the immigration field in broader terms, actually, she was using also the freedom of information access as a tool to access information concerning where AI tools are implemented. Do you have you considered to use this method also to get access to this information, or do you suggest any other tools for methodology? Thank you very much.
Thank you, Agnese. I see now Ismini and Camilla. So if you could please intervene in this order, thanks.
Yes, hello. Hi, Niovi. Thank you very much for another very insightful presentation. I wanted to ask a question regarding the last part, because I feel like we didn't have so much time, to go through it. So it was basically, I am familiar with the second case study, and I was wondering, and I was also astonished at the fact that they just dropped the algorithm right away. But there is also the question of whether we know whenever they're going to use it again, if it's going to be changed, like essentially or not, because we cannot know that either. So would it take like another walk to the court, let's say, to figure this out? And the question is actually, how easy is it to challenge specific systems before the court in order to ask for them to disclose, the information related to the algorithm? And if it is the case and it is possible, why don't we do it more often?
Thank you. Camilla?
Yes, so just a short question. Thank you for a wonderful presentation. My question is, what is the role of the judge? Putting it very simply. So when whereby AI system is used, for example, only in the administrative procedure, for example, an administrative asylum procedure, what role is left to the judge in deciding? And you touched upon this on the last part of the presentation, and as I'm connecting my question to Ismini as well, and to what was raised in relation to the right to effective remedy. So how made the judge be a sort of shield against discriminatory decision making, and how will its role change in the future? That's it.
Thanks a lot. Niovi, would you like to start addressing those questions?
Thank you very much for your insightful questions. Okay, perfect. With regard to the first one on the methodology, I am very fond of FOIA requests as well. I think this is a very good methodology to get some clarity. I work primarily with EU systems and EU AI systems, which means that these FOIA requests have to be addressed not only to EU institutions, but also to EU agencies and other bodies. So I think this is a very good strategy to get some more clarity in information, but I don't think that's the only one. The second one would be to raise awareness, because unless you raise awareness and you train lawyers who are, and I think the training should be at both sides. I think that essentially migration lawyers need to be trained on the use of AI in migration, but also technology, IT lawyers and data protection lawyers, for instance, should be trained on migration matters, because there needs to be synergy of both in order to understand very well how these systems operate. This is not a very easy task to do, but I think this is not only after you get awareness, you can strategically aim for litigation. I think strategic litigation will be the very next big thing in this field, because when you, but the problem there is to actually find the right people in order to go before the courts. Because if you, and for that you need to wait, you need to be very patient, because a lot of people, first of all, a lot of people do not really, a lot of the systems are not being deployed. So you don't have potential applicants at the moment. So you can only find information about how the things are being used. And how they are developed. But let's say that once they become developed, then the strategy will be to actually raise awareness among lawyers and among individuals who are subject to the system, so that you can identify potential applicants to go for strategic litigation. This is, as I said, not easy, because, and something that we discussed with Mirko before we started, as you can appreciate, a lot of these people who are subject to the AI systems are not going to be placed within a national territory. So you need to find them in their countries of origin, or in borders, or in detention centers, and it's not that easy. Especially when their main preoccupation would not be what happened to the data and how decision-making took place, but when they have other preoccupations. The good thing is that so far, the technological aspects had a lot to do with privacy and data protection, which were indeed more secondary preoccupations. But when your actual applications are being decided on a potential discriminatory basis, then I think that there may be more incentive for people to actually challenge these decisions, because it actually affects their position, not only their data. So I think there is quite a lot to be done there. Which gets me to the next questions, which have to do what happens and why we cannot go to the courts. And I think I partly discussed that. It has to do with the fact that a lot of these people, there is lack of awareness, lack of fully developed systems so that you can challenge something already. And also there is sometimes also lack of awareness also on behalf of judges, and lack of understanding of how the technology works. So my experience has demonstrated that when it comes to migration, and I'm talking about the Court of Justice of the EU, which is because that's my primary expertise, the judges are more prone to be accepting the EU technologies rather than questioning their fundamental rights compliance. This is something that I've seen hidden in some judgments, and I think that may create some challenges and some concerns as to the potential outcome of decisions before the Court of Justice if those systems were to go and be litigated against. In principle, I think that the role of the judge depends a lot on the country. We can see, for instance, that in cases where AI was at stake in the US, the role of the judge was quite prominent, but there was no important role for the individual. So the judge should have access to the algorithm, but not the individual. This is not the case at EU level, where the Court of Justice has said that the judge should definitely have, and in principle, the individual should also have some information unless there are state security reasons. But the judge should have access to the algorithm in order to be to appreciate whether there has been discrimination. It should have access to all the underlying documents. But again, this means that the judge should be well trained to understand these aspects, which is also a challenge on its own, because sometimes judges cannot fully appreciate what is the impact of technology. They may have their own biases. I said that at least in some judgments, I don't see bias, but I see lack of full understanding or more acceptability of some technologies. So I think that a lot of interesting things are going to happen, but we have to wait. I think it's time to raise awareness for now.
Yes, thank you, Niovi. Also for this positive note, we have a question from the floor. If you could please join us to pose your question. Thank you. Sit here. Here. It's better if he comes here so they can see you, otherwise.
Thank you so much for the presentation. I really enjoyed it. I have three software clarifications, but I will post them on your mail to clarify. I want to get one thing. I see that of all that was presented, it seems to be a problem of transparency on how AI functions and how the users can better understand the results of AI. So my question is this: is there any existing transparency tools currently being considered for use in AI, such as data capturing transparency tool that will relate to the data subject, what has been captured and what was used in rating the data captured? Another transparency tools like AI results conveyance tool that will convey to the data subject what has been used to analyze the data and the performance. I believe if there is a tool of this nature, we can better understand how to remove these impediments. Because like we said, currently, without AI, we witness all the incidents that you have enumerated, to which the fear of AI is being opposed. But with transparency tools, if it does exist, do you think this can be eliminated? Thank you.
You are muted, actually, and we cannot hear you.
Cannot hear me. Okay, thank you very much. So as I said, now maybe this is the pessimist note, not the optimist note. I think that transparency tools are very important. I think that a lot of getting information about what is actually happening, what is being deployed, even informing individuals, I don't think that this is that easy. But the performance, for instance, performance of the tools through reports, through oversight mechanism, it will happen. It may unearth discrimination or other human rights concerns, but I think it can take years before this can be eliminated. I'm trying to be very careful here because I don't want to sound too pessimist, but I do believe that the discrimination is so much embedded and so well hidden that even transparency reports may not be maybe enabled to uncover what is really happening. So we have to wait for some years for sure. First of all, to be deployed, to be used in practice. We know that in the UK, there was discrimination in the applications, but very soon it was scrapped. With the proliferation of the tools, we will get more information. So we may be in a better position to understand structural discrimination and maybe get better understanding. But I do believe that this is a field fraught with discrimination, and I'm not entirely sure that actually it can be ever eliminated. I actually believe that it's going to be perpetuated.
Okay. So many thanks again, Niovi. I guess we might have time for a very last short question. So if you want to take advantage, yeah, okay. So could you please come here? Do you mind coming here?
So I have a simple question.
Could you see it? Otherwise people
Okay.
see this.
Sorry. Okay, so I have a very simple question. So do you really think the automated decision-making systems are always helpful to the key players in the process, like the administrative bodies, then immigration officers or lawyers whom we were talking? So are they always helpful, or is there any drawback of that, if there are?
Whether they are always helpful. I think to a large extent, this is something to ask administrators and decision makers. I think they will value because they will make their life a bit easier, and they can blame it also on the algorithm if something goes wrong. It wasn't them, it was, the system that gave the wrong recommendation. It can potentially make their job more difficult if the recommendation by the system is against their normal course of work. So for instance, if it flags odd people that they wouldn't normally be flagged and they wouldn't normally be denied a permit or a visa or whatever, then it may make their life actually more difficult because they will have to spend quite a lot of time into manually examining an application. So, but I think that they value quite a lot the simplification of their lives. I've had the discussion, I think I'm going to finish with that in order to understand how this can play out in practice. So I was talking to someone who has been reviewing visa applications in a consulate.
But in case if there are any demerits, which again the immigration officer has to sit back and he has to
take a better look. They may have to spend more resources on applications that they wouldn't normally spend that much time in order to see what's wrong, why the person has been flagged, because this may go against what they would have normally done. So that's one. Also, they will need a lot of training. They will need, they have to adjust their job as well. So going back to my example, to understand how the machine can actually influence, the visa assessor told me that when they see a photo of the applicant at the front of the application file, they know 80 to 90% whether they're going to grant a visa application or not, judging from the photo. I think that's very telling of how the screening of visa applications can take place, and they know the rigorousness of the visa application already at that stage. Where they come from and they see the face, they can they can sense how difficult the examination can be. Imagine having also a machine telling you that this is a risky person. What would you do? How easy would it be to actually go against your instinct and the machine and actually give this person a real shot in actually examining the application? So I think I'm going to stop with that, and it's quite telling of how things can actually get worse. I know it's a little bit pessimist, but I do value the work of NGOs, of lawyers, of academics, and of the judges in order to bring more clarity as to how these are going to work out in the future.
So thank you, Niovi. Thanks a lot. It was great having you, and thank you for your generosity. This was really a rich and enlightening presentation. Well, we are having now a break for 10 minutes, and we will resume at 12. Please, in order to make up for the time we lost due to the technicalities in this morning, try to come back in 10 minutes so we can have the second speaker and then go for a lunch break. Thank you very much. Okay. Just a second. Okay, so we are back. Thank you for your patience with these technical issues we are experimenting today. I kindly ask all of you in presence to please make silence so we can start. And we have our second speaker, who is part of the Tuscia family. Dr. Mirko Forti. Mirko is a postdoctoral researcher here at Tuscia University, and has a lot of collaborations with several networks and institutions in Italy and Europe. He is also an invited expert on migration law for the European Center of Excellence on Countering Hybrid Threats. We have the pleasure to have Mirko today dealing with artificial intelligence failure at the EU borders. And hopefully we will fix this echo now, and I'm leaving the floor to you, Mirko. Let's see if it works. Thank you.
So thank you very much for the introduction. Thank you very much for the invitation, first of all. And well, artificial intelligence failures at EU borders. But before starting with our lectures, I would like to know your opinion. What are the first things that comes? Something is going on. Maybe it's better. No, the echo is still going. Don't know. Maybe it's better now. No, the echo is still going. Oh, no. I don't know if the echo is still going. Yep.
Try now.
Let's try. Let's try now. No.
Microfono, altoparlanti. Vedi così. Ora?
Let's try.
Okay.
Let's try. Maybe it's better. Okay. Sorry for the technicalities. And what I was saying, I would like to know, in your opinion, what are the first things that come to your mind when we talk about artificial intelligence? There is no right answer, so feel free to speak. Efficiency, something else? Also from home, obviously. Efficiency, accuracy, fast processing, and sorry? Time saving. According to your opinion, what are the common traits, the shared features between all these words? Well, artificial intelligence is often addressed as the best way to process data. The more scientific, the more reliable way to process data. And the point of my lecture today, the point of our discussion today, is that artificial intelligence could be not so smart, could be not so intelligent. So artificial intelligence failure at EU borders. The focus will be on fundamental rights implications and accountability concerns. How artificial intelligence going wrong could affect the fundamental rights of people on the move. So a brief outline of my presentation, first of all, introducing the EU digital border scenario. So what are the main technologies, the main technological solutions currently operating at EU border scenario, on what grounds they are operating, for what aims and goals. Artificial intelligence and algorithmic error. So we are talking about artificial intelligence, but what is artificial intelligence? What are algorithmic errors? How an algorithm could go wrong? Algorithmic errors and fundamental right consequences. So how algorithmic errors, algorithmic mistakes and failures could affect the fundamental rights of migrants, refugees, and asylum seekers. What are the main legislative safeguards and legal remedies in place to protect the fundamental rights of migrants, refugees, and asylum seekers? And a few concluding remarks, trying to think about the possible developments of artificial intelligence-driven borders. So, introducing EU digital borders. You have already discussed these things in your previous, in the previous lectures of these summer schools, but what are the main tasks of EU digital borders? First of all, the preemptive detection and interception of incoming migration flows. And Eurosur is a crucial asset in this regard. Eurosur is a sort of network surveillance system putting in cooperating between EU agencies and EU member states, allowing information exchange between EU agencies and member states in order to improve situational awareness and increase reaction capabilities. So several technologies operating in EU borderlands, including sensors, cameras, drones, unmanned vehicles, and so on and so forth, radars, satellite imageries, in order to collect data put between EU member states and EU agencies in order to understand what's going on at within the EU borderlands. Another task is the identification and conduction of data-driven risk assessment procedures of incoming third-country nationals. You already know from your previous lectures that there is a network of interoperable large-scale information systems collecting several types of data: biometric, anaglyphic, location, geographical data from third-country nationals for various aims. Various aims including border protection, counterterrorism, migration management, and so on and so forth. We have already introduced a few of the main criticalities of EU digital border scenarios. So the overlapping of different actors operating in the same scenario, member states, international organizations, regional organizations, operating but not cooperating, operating for various aims that could collapse, that could overlap. The increasing digitalization of EU digital borders relies on securitization approach to migration issues. People on the move, migrants, refugees, and asylum seekers are seen as potential security threats to EU safety and stability. So migrants could be a destabilizing factor to EU member states. So the progressive datafication, the progressive deployment of surveillance technologies is in place to track the movements of incoming non-EU citizens, to identify, detect, and track the movements of migrants, refugees, and asylum seekers, so gaining knowledge, gaining power over the movements and the actions of migrants, refugees, and asylum seekers. The deployment of data-driven technologies influences the development of EU migration management policies, transforming, in first place, the notion of border itself. Border is not anymore a mere demarcation line, but borders are gradually proliferating all along the immigration journey. And in another sense, borders are gradually becoming part of the migrants, because migrants have to share their body, through their retina, their fingerprints, and so on and so forth. So the borders are gradually becoming part of the migrants' body themselves. Borders are gradually becoming digital filters filtering the mobility of migrants, refugees, and asylum seekers accordingly to potentially discriminatory variables, including race, ethnicity, nationality, language, and so on and so forth. So borders are gradually becoming sites that serve social sorting processes for security purposes. EU digital borders entails, relies on techno-policy grounds. Techno-policy grounds including a techno-solutionism approach. So technology seen, addressed as a sort of panacea, as a sort of solution to all the migration management issues. EU institutions and EU member states are putting an unwavering amount of trust in the technological capabilities to analyze the surrounding context and forecast possible developments. So data processing analysis is seen as the only way to understand what's going on and to react as a consequence. The techno-solutionism approach, as sketched out, relies on data realism assumptions. So data are seen as truthful representation of reality. Data are seen as a sort of truth tellers, a critical, a political, scientific truth tellers. But this is not true. This is not true. Why? The deployment of technology influences the rationality of society. This is the concept of technological rationality introduced by Marcuse. So technology could influence the socio-political development of societies and of members of society themselves. Could you make a few examples of this, how technology could influence the actions of members of a society? Any idea? Any idea?
Discussion with the board, if it's maybe closing the borders or a little more, in a sense that it is maybe known in the public that this particular information is using an AI bias or is known to have discriminatory patterns. Therefore, people will, I mean, their behavior will change. They will move a different way. They will go so the full vector will.
Exactly. Oh, sorry, sorry, I haven't seen that. Anui and Isabel,
Yeah.
please, Anui.
Yeah, I couldn't hear the previous participant.
Please, Anui, if you want to tell us something.
Yeah, could you hear me?
I don't hear you. We cannot hear you.
We can hear you, Henry.
Okay.
We cannot hear you. Sorry.
Okay, I don't know what to do.
Yeah.
Maybe write
yes.
in the chat. I don't know, because we can
Yeah.
hear you. So
Yeah.
yeah, the problem there.
Now we hear you.
Oh, okay. Perfect. I was gonna write in the chat. No, I couldn't hear the previous participant's response, but in terms of member states and even like citizens, their decisions could be impacted with access to data. So if we have runtime data, dynamic data on migration, that could influence the perceptions. And as we know, like voting behavior in the long run, not even in the long run, could be impacted a lot with the access to data. I would say that's one of the implications.
You're right. Thank you for your contribution. And I think also Isabel.
Yeah, no, I'm gonna lower my hand because I was going on the same direction that what Anut said. So
We cannot hear you.
can you hear me now?
Yeah.
No, I said that I was gonna lower my hand because I was going to say something in the same direction that what Anut said. So I think it's pointless. It would be we already seen what the use of technology can do to impact and to have an impact on what, and try to shape what people are thinking, and they can influence what people think about the matter. So if we think about especially about the prediction of migration flows and all that, this could raise even bigger concerns on how the countries that are receiving that flow, the society will respond to that, because they will also have the forecast information about that, and they can also react and anticipatedly to this flow. So I think it could.
You're right. You're right.
Impact in a negative way.
Technology could influence policy actions in various ways, and also, as your colleague here in the room rightfully pointed out, technology and surveillance technologies could influence the actions of people under surveillance. People under surveillance could adapt their behavior in order to avoid digital surveillance operations. Let's think about migrants burning their fingertips in order to avoid that their fingerprints could be collected by EU member states. Another point to make: the data as a matter of concern and not a matter of fact, as pointed out by Bruno Latour. So data as not a source of a critical truth. So data are not a scientific, apolitical truth. Data, in order to be rightfully interpreted, should be considered within a determined socio-political environment. So, what is the main consequence? What is the main consequence of such a techno-solutionism approach to border management? Migrants are addressed as data. Migrants are addressed as data and not as humans. So there is an ongoing depoliticization of their needs and experiences. According to your opinion, another consequence of such dehumanization of migrants, what could it be? Well, the dehumanization of migrants could lead to disregarding their human rights. They are not humans, they are data, so they don't need human rights. Yeah. So focusing now on artificial intelligence, at the borders. Artificial intelligence could perform several operations in the context of border control and migration management. For example, risk assessment operations to prevent migration-related security threats. It is the role of the ETIAS, the new border management system. Pros and cons of artificial intelligence-driven borders. Pros: fast data processing activities, increased cybersecurity capabilities, and also ET management operations. But what are the drawbacks? Fundamental rights risks, lack of transparency, and the occurrence of algorithmic errors. We are talking about artificial intelligence operating at the borders. But what is artificial intelligence? What are algorithmic errors? So artificial intelligence could be portrayed, could be addressed as a sort of umbrella term, indicating a vast array of technological solutions in continuous transformations, in continuous evolution. What are the main tasks of artificial intelligence? Artificial intelligence could provide human observers with a sort of statistical explanation of the relationship intercurring between two or more elements. So moving from a sort of input, the so-called prompt, the questions asked at the artificial intelligence algorithm, the software could provide us with a statistical explanation describing the relationship between input A and output B. How they can do so? Applying hidden patterns, applying hidden correlations retrieved from training datasets. What are training datasets? The knowledge of the artificial intelligence software, the previous experiences of artificial intelligence software. So applying such hidden patterns retrieved from training datasets within the surrounding reality, within the reality under exam, in order to find applicable correlations, in order to find statistical correlation. Can you follow me? Okay. This is in very, very, very general terms how artificial intelligence algorithms are functioning. So talking about errors, statistic condition leading to artificial intelligence failures. Artificial intelligence failures, so algorithm unable to perform its function, unable to perform its tasks. Focusing on the border scenario, focusing on the artificial intelligence-driven border scenario, what does it mean? Poor performing in risk assessment operations and identification procedures. Now delving more in depth into the topic of our lectures, artificial intelligence errors, how they can be possible, how they can occur. Group data predictions, for example. As we said before, artificial intelligence algorithms base their functioning on previous data processing analysis, on previous data processing experiences. Artificial intelligence algorithms make predictions against group data benchmarks. So they adopt statistical correlation, they adopt statistical functions in order to analyze their data. They analyze their data accordingly to previous experiences and to previous group data. Let's make an example. Artificial intelligence algorithms could make group data. So white man, Caucasian, Black African male, and so on and so forth. So subjects not belonging to the statistical majority, not fitting within these statistical majority groups could represent an anomaly to the artificial intelligence software. And this is particularly crucial when we talk about artificial intelligence assessment of individuals belonging to minority groups, belonging to vulnerable groups. They could represent an anomaly to artificial intelligence algorithms that could be not able to understand what's going on, that could not be able to fit such particular individuals within the statistical majority groups and could lead to discriminatory treatments. We are talking about statistical explanations. So correlation is not causation. Correlation, the existence of statistical relationships between two or more objects does not imply that these two or more objects are in a relationship of cause-effect. Let's make an example. Let's make a famous example about that. Scientists from the United States proved that there is a sort of correlation going on between deaths for drowning in the United States with the release of movies, with the release of films played by Nicolas Cage. And I don't think that movies played by Nicolas Cage could lead to deaths for drowning. So correlation is not causation, and this should be very clear to human agents, human actors using artificial intelligence algorithms to form their policies. Data compression, artificial intelligence algorithms are capable of analyzing, of processing vast amount of data because they previously compressed, they previously elaborate such data. But information compression could imply the loss of relevant information. Let's think about a very basic example. We take a picture with our phone and we try to upload these pictures to Facebook, Instagram, and so on and so forth. We immediately notice that the picture in our phone is more detailed, more clear compared to the pictures uploaded to our social media profiles. Loops and biases. Biases are already introduced by Niovi in our previous lectures. Feedback loops. Feedback loops imply the misinterpretation of surrounding reality. So artificial intelligence going in a feedback loop will mean that there is a misinterpretation of the data under analysis. So erroneous outputs, because misinterpretation of surrounding reality would lead to erroneous algorithmic outputs that could become misleading inputs. It's a sort of circle. Outputs becoming input for the next working routine of the algorithm. Misinterpretation of training data sets could be overfitting and underfitting, and an algorithm going overfitting would mean that rely too much on the training data set, so looking only for exact matches between input A and output B. So disregarding any other possible correlation and disregarding any other possible statistical explanation. Underfitting is the reverse, is the contrary. So algorithms not capable of interpreting the data sets, not capable of retrieving possible algorithmic explanations for explaining the relationship between input A and output B. The misinterpretation of the surrounding reality due to algorithmic technical failures could lead to biases. What are biases? In very general terms, biases are specific data generalizations instead of another. Datasets, what are datasets? Datasets are a specific perspective on reality. Obviously, algorithms could not know everything. They rely on specific data implying a specific perspective on reality, thus losing the inherent complexities of the reality under analysis. A very general classification of biases. What biases? The losing of the complexities of the reality under exams. So we are living in a world of biases. Every one of us has a specific perspective on reality. Data biases and algorithmic biases. The replication and propagation of word biases through data analysis and algorithmic computational power. It's now time to introduce the elephant in the room. The elephant in the room is data quality issues. I said here, garbage in, garbage out is the main scheme, is the more general way to describe data quality issues. If you put garbage into the algorithm, you will have garbage. You will have erroneous outputs. You will have erroneous, misleading outputs, misleading algorithmic outcomes. Focusing on the border scenario, data quality issues could affect the functioning of artificial intelligence-driven borders in many ways. Let's think about spelling errors, spelling mistakes when recording the names of incoming migrants, errors in the transliteration of names written in different alphabets in the Latin alphabets. Birth certificates that are not updated, that are not reliable, technical failures, and so on and so forth. Algorithmic errors could have detrimental fundamental rights consequences. For example, let's think about the so-called self-fulfilling algorithmic prophecies. We are black and border guards hate us. The computers hate us too. These are the words of Adisu, an Eritrean migrants in Brussels living undocumented, and he powerfully described the relationship between digital border guards and incoming migrants. Data-driven border control activities could move from unreliable data, from low-quality data, and propagate discriminatory assumptions. So erroneous outputs, as we said before, could become misleading inputs, thus confirming and reinforcing algorithmic discriminatory results. We can make an example, so not inherently linked to the border scenario, describing this tendency. Algorithms operating in a few hospitals in the United States were found out as discriminatory. Evaluating a lower score to black patients, preventing them from accessing social healthcare services, social health services. Why? Because algorithms consider that black individuals don't access so often hospitals and so on and so forth. So, according to the algorithm, they don't need social healthcare services. They don't need access to healthcare services. But algorithms in this way do not consider many other factors informing the choices of black individuals. For example, the low economic conditions preventing black individuals from accessing healthcare services for payment. The fear of becoming subject of racial discriminatory treatments, and so on and so forth. So algorithms could lead to the propagation of discriminatory treatments, preventing individuals from accessing healthcare services, relegate them in a difficult situation, relegate them in a more vulnerable situations. So propagating discriminatory attitudes, propagating discriminatory treatments, and leading to networked discrimination events, discriminatory treatments originating from previous biases as a consequence. The algorithm black box, trying to introduce this topic, this theme. Human observers cannot detect and understand the reasoning pattern adopted by the algorithm to go from input A to B. How to detect algorithm errors, how to detect when and where the algorithm goes wrong. The opaqueness of algorithmic functioning will prevent human observers from being morally accountable for the implementation of artificial intelligence outputs. Artificial intelligence algorithms seen as reliable judges, seen as apolitical judges. Judges not suffering from prejudices and biases. So it's not my fault. The algorithm says so. So I'm not responsible of this algorithmic output. The algorithm says so, and I trust the algorithm. So introducing the automation bias, who is the judge? The human implementing the algorithmic outcome, or the algorithm itself producing the algorithmic outcome that is not challenged by the human observers, by the human actors. Focusing on the juridical perspective, focusing on the legal perspective, there is a lack of compliance with the right to good administration, Article 41 of the Charter of the Fundamental Rights of the European Union, and the right to legal remedies, because how to challenge policy decisions, how to challenge administrative decisions relying based on algorithmic outcomes that we don't know if they are wrong, if they are erroneous, if they are misleading. There is no grounds for appeal because we don't know how the algorithm said that these individuals will not obtain a visa, will not obtain a residence permit. We don't know why. And how the algorithm said that these individuals are risky, are bringing a security threat for the EU member states. Okay. Artificial intelligence-driven borders and data protection issues, going very quickly. The artificial intelligence borders could imply several issues for data protection, data minimization. Algorithms need vast amount of data in order to perform their functioning. Purpose limitation, we have already said that artificial intelligence-driven borders could be used for migration management, border control, counter-terrorism, and so on and so forth. What room for fairness, transparency, and lawfulness? Artificial intelligence errors and data subjects' rights, right to be forgotten, right to access and erasure, right to information, and so on and so forth. The algorithmic black box could prevent the right implementation of such rights. I think we can skip this, and this. I would like to focus on the artificial intelligence legislative framework. We are now discussing the Artificial Intelligence Act within the European Parliament. artificial intelligence-driven technologies deployed for migration management pool posts are labeled as high risks, thus requiring additional legal safeguards. But the recently discussed ban on artificial intelligence-driven profiling and prediction activities does not apply to the border context. So the balance between the protection of fundamental rights of people on the move and the intention, the willingness to have security, to have the secure borders, to have unviolable borders is on the last one. So security, according to the European Parliament, is more important than the fundamental rights of people on the move. Artificial Intelligence Liability Act introducing the so-called fault-based liability approach when claimants need to prove the defendant's guilty behavior previously before holding them liable. Talking about legal remedies, the action for annulment directly targeting individuals could request the annulment of EU acts grounding on unclear and insufficiently detailed basis, but data-driven border control activities do not require the adoption of legally binding acts. And also the algorithm black box could prevent us from having a detailed basis for EU grounding for EU acts. Action for damages requiring compensation for harmful conducts perpetrated by EU agents. How to prove the causal link between the digital conduct and the harmful event. Going to the conclusion. We need a clear governance framework. We need clear governance framework individuating the legal responsibilities for all the actors operating in the EU digital border scenario. We need periodical necessity and proportionality checks to understand if we need such intrusive, such pervasive surveillance procedures. And we need to implement, we need to provide people on the move with adequate legal remedies to spot and individuate and identify algorithmic errors and request protection from the detrimental consequences of algorithmic errors. Thank you for your attention. I don't know if you have any questions.
Okay, yes. Yes, thank you. Thank you, Mirko.
Thank you.
It was great to see also the integration between the first and the second presentations. We have, let's say, 20 minutes for the Q&A. So please go ahead from the Zoom chat or raise your hand here in the classroom.
Maybe.
Okay, could you please come here? There is the echo issue again.
Thank you. Thank you very much for your presentation. And my question, or more of a concern, I guess, would be connected to the algorithmic black boxes that you were discussing, because as it is known, as it currently stands, we don't specifically understand how AI is how is it putting the output, making the concrete decision. And as far as I understand, it won't change. So this fact that we don't understand, it might even become worse. Like, since the AI is also evolving in time, and it involves much faster than human beings can catch up, I see a lot of risk in this, because if now from the current standpoint, we don't understand how the decisions are made, therefore we cannot challenge them, because as you also said, we have to have some kind of evidence, we have to have an understanding to come up with counter arguments, so to speak. Then what perspective do you see? Do you think that it will change and we will catch up to the machines? Because I don't necessarily think that that could happen, considering the speed of the development of AI and the development of our understanding of it. Thank you.
Maybe Mirko, it's better you take this one and then we see. You can stay and just
So if we can catch up with the evolving nature of artificial intelligence algorithm, if we can understand the reasoning patterns of artificial intelligence algorithms, short answer, no. More detailed answer. I think the answer is no for different reasons. First of all, technical reasons. So we use algorithms because they are more powerful, and they are more powerful than human minds. If we understand the reasoning pattern of artificial intelligence algorithm, will mean that we will have the same reasoning pattern. So we don't need the algorithm. I think this is the first question.
But isn't it scary to deal with something that's much more?
I think this is the first question. And I think there are also several interrelated policy issues. We need to understand why we need to give so much trust on something we don't know, we don't fully understand. And I think that we need to find a proper balance between all the issues at stake. We need to understand that if we would like to prioritize our aim for transparency and clarity, or we would like to prioritize our aim for security borders, for fast processing models activities. And I think that nowadays the policy answer is on the last one. So we think that it's more important to have fast processing data-driven borders more than protecting the substantial rights and the procedural safeguards of people on the move. And I think the answer is that. I think the balance is not so much a balance. It's disproportionate towards the security perspective.
I agree with you also. Thank you so much.
You're welcome.
Okay.
I think we have.
So there is another question from Zoom. Isabel, please go ahead.
Yes. So first of all, thank you very much for the presentation. I thought it was really brilliant. And can you hear me now?
Isabel, just a second. We cannot properly hear you. Try again, please.
Oh.
Okay, it's working now. Great.
Now? Okay, I don't know what I did.
Was great.
Well, first, I thank for the presentation, and my question actually is about the idea and the concept of border. It's something that I start thinking when you were saying about the gradually change of the border in becoming a data collection and elaboration sites. And that made me think that we are now facing another change in the concept and in the idea of border. So what would that mean I mean, can we say that we are now technologically advancing Europeans' borders beside the concrete and the real borders? And what would be the consequences of this new change in the whole concept of border? I don't know if I'm making myself clear enough with my question, but yes, it's something that now you made me think about it. And we are also facing an advance on the whole surveillance, that we are not only now proposing to be vigilant in the actual border, but we are legally now saying that we will expand the surveillance as beside far away from the concrete border. And this was something that maybe a couple of years ago, it was something that would be considered illegal to expand surveillance inside other countries. But now this is becoming something reasonable, and with the legal framework, in order to best assess security threats and to best manage our borders. So would we be facing now a new border idea, and what would that mean?
So thank you very much. Okay, thank you very much for your question. And you are absolutely right. You are absolutely right. We are advancing. Our borders, European borders, outside and beyond the European territory. And this is going on not only related to the technological issues, but also related to the technological issues. So we are now advancing our borders, our techno-driven borders, in various ways. So patrolling European Union borderlands through the deployment of cameras, sensors, satellite radars, drones, and so on and so forth. Eurosur is the paradigmatic example in this sense. So European Union data-driven borders are not a mere demarcation line, but are something that is continuously propagating also beyond the European territory. And the propagation of European data-driven borders is also inherently linked to the border externalization phenomenon. So collaborating with non-EU countries, with third countries, in many ways. For example, sharing surveillance technologies with non-EU countries. This is something that is already occurring within the framework of EU-funded programs. I was thinking about the EU Trust Fund for Africa. So sharing surveillance technologies with the countries of origin of migration flows in order to prevent migration flows from approaching EU frontiers. And it is a particularly crucial topic because it's happening in a sort of legal void. I'm trying to explain me better. Trying to point out a few research questions, so we can say so. What are the legal obligations of actors operating in the externalization of EU data-driven borders? Because we are thinking about several actors, non-EU countries, EU countries, EU agencies, also private suppliers, the private suppliers of surveillance technologies, so tech industries, surveillance industries. What are the fundamental rights obligations of all these actors operating in the border externalization scenario? So you are right, pointing out that EU data-driven borders are advancing also beyond the European territory, and they are advancing in a sort of legal void, in a sort of overlapping of different jurisdictions, and it is a particularly crucial topic to be addressed both from academics, but also more important, more relevant from lawmakers and policymakers.
Okay. Okay. Let's check if there is a very last question. We know it's lunchtime. And again, accept our apologies for the technicalities we had today, but we coped. We coped with them, and it's great. I mean, that we had those two colleagues who very generously delivered, lectures on a complex topic and a very uncharted field of analysis, I would add. Okay, so I think there is no questions. Then I will take a few seconds to inform all the participants in this summer training school that the Center of Excellence on the Integration of Migrants in Europe has been renewed. So a few minutes ago, we received the communication from the European Commission that we had another grant for the next 3 years. Which is just amazing, because it means that we can continue all the activities which are running through the center. So we're very happy for this. And on top of this, tomorrow, for the closing of the summer training school, you are all invited to join this trip to Rocca dei Papi in Montefiascone, which is a small town nearby, a beautiful place full of history. And a shuttle bus will come to pick us up here at these two departments tomorrow morning at 9 a.m. So please be on time, because we are on a tight schedule and we have to start the lectures in Montefiascone at 10 o'clock. So it's very important that you be here at 9 a.m. tomorrow morning. And the classes will be through the entire morning. So we will finish at 1 p.m. and then we will have a guided tour to the beautiful city of Montefiascone and Rocca dei Papi in the early afternoon. I recommend you to enjoy the gardens, which are just, close to the tower of Montefiascone, where we'll head in tomorrow, which are beautiful, and near the gardens you can find a lot of places, restaurants and bars for the lunch break. Then the shuttle bus will bring you back here in Viterbo around 4 o'clock. So this is the time. The guided tour will run from 3 to 4, let's say, for an hour. We know that it's really warm, but at least one part of the guided tour will be inside in a museum. So please come tomorrow for this nice closing experience, and thank you for your participation today. No,